From National Review headquarters in New York City, this is a Capital Writing author interview. Our guest today is Philip Howard. He's the author of the book Not Accountable: Rethinking the Constitutionality of Public Employee Unions. He is the chair of Common Good, a nonpartisan advocacy group that tries to make government a little bit better. And one of the ways to do that is by taking on public sector unions. And so thank you so much for being with us today, Philip.
Nice being with you, Dominic.
All right, so I guess can we start with just a lay of the land on public sector unions? Where are public sector unions allowed, and what areas of government are they most prevalent in?
Public sector unions were only authorized in the late 1960s, generally, and they're allowed with variations on what they're allowed to do in the federal government and in 38 states.
Yeah, and when we talk about the federal government, I think a lot of the times, we see these more often in state governments. We see them in places like teachers' unions, places like police unions, firefighters, and those are all state and local jobs. Right. But we also see it in some parts of the federal government, but not as widespread, right?
It's not as widespread, although in general, the unions are concentrated in state and local settings in blue states, basically, and also in the federal government, sort of more in some agencies than in others. Overall, the federal civilian workforce is about 25% unionized, whereas the state and local workforce is more closer to 40%.
Okay. And at the state level, when we're looking at the states that do allow, you said 38 states have them. That would mean 12 don't. So how were some of these states able to avoid this and others were allowing it?
Well, actually, just because they've avoided collective bargaining doesn't mean that they've actually avoided the unions completely. So there are a number of states that don't allow collective bargaining that nonetheless have what are known as meet and confer laws. And the unions over the last 50 years have used the organizing power of collective bargaining nationally to amass incredible political treasure chests, or for use in campaigns. So they're influential even in states where bargaining is not allowed.
Mm-hmm. And when you talk about collective bargaining, what are the kind of things that unions are negotiating when they come to the bargaining table?
Right. Well, I think there's a lot to talk about here. In general, the way collective bargaining in the public sector works, which is very different than the private sector, which we should get into, is that over the last 50 years, the public sector unions have bargained for procedural protections that basically make it impossible to hold anyone accountable. So there was an 18-year study in the state of teachers in the state of Illinois that found that an average of 2 out of 95,000 teachers per year were dismissed for performance. That's twice the rate as in California. So we're talking about basically zero. 99% of all federal employees get a fully successful rating, because the procedures provide that if you put one negative comment in a file, like doesn't work as hard as others or something like that, doesn't cooperate well, the supervisor will find himself in a legal hearing, having to prove it, with union lawyers on the other side. It's just too much trouble, so no one does it. So accountability has disappeared, and manageability has largely disappeared. So resource allocation, you want to put some people doing this instead of that. The work crew sees an overhanging limb that they should cut, but no, the rules don't allow that. You have to have a separate work crew to come in to do an overhanging limb or whatever, cut an overhanging limb. So incredibly rigid work rules, and then financially, over the 50 years, they've gradually clawed more and more out of the pension and retirement and healthcare benefits, things that are somewhat opaque to the public, so that state and local government public safety officers can generally retire after 20 or 22 years. So they're retiring in their early 40s and with full pensions, and often go back to work in the same place. So they're collecting double. There's a phenomenon known as spiking, where people get their pensions are determined by their last year or two's compensation. So they work lots of overtime in the last year or two, and then they double their pensions. There no requirement to contribute to healthcare. So, in New York City, the zero healthcare contribution compared with the way the market would work or in other places is, I mean, we're talking about $1 billion or more a year. So it's made government unmanageable because of no accountability in the work rules, and it's made government unaffordable.
Yeah, you had this list on page 63 of your book listing some of the rules that teachers unions are allowed to bargain with, and I just want to read this because it was so crazy. Some of these rules. The rules that require principals to give advance notice to teachers before visiting their classrooms to evaluate performance. Rules that prohibit the use of standardized student tests for evaluating teacher performance. I can't think of a better way to evaluate how teachers are doing. Rules that specify all the procedures that must be followed if a teacher is evaluated as unsatisfactory. Rules that give teachers guaranteed preparation times of a specified number of minutes a day. Rules that limit the number of faculty meetings and their duration. Rules that limit the number of parent conferences and other forums in which teachers meet with parents. And I mean, this goes on and on. And you say in the book, you're like, if we were designing schools to educate children, these are not the rules that you would have in place. You would do other things, and you would
no. So the rules. I was on a podcast recently with Bob Schrum, as a prominent Democratic, advisor and such, and he was saying how these contracts are the only protection of the public workers or whatever. I said, first of all, they didn't really need protection in the late 60s. There was no reason. It wasn't like the children were being mangled in factories. Most workers were doing just fine. They had civil service protections and all that. They just wanted the power. And he was sort of pushing back. And I said, well, just give me one example of a requirement in these contracts that's good for the public. Just one example. These 200, 300, 400-page contracts filled with the kind of requirements you just read out that are all designed to make it so that if you want to do anything, to adapt to any daily situation, you have to basically get the union's approval. So he thought for a minute, he said, the teacher union negotiates for smaller class sizes. I said, aha. And it's only coincidence that results in the hiring of more teachers. I mean, that's one thing. So it's, I was at being interviewed by the columnist Joe Klein recently, and he talked about how his wife was trying to go to a parent conference for their daughter, and there was a line of parents, and they really, this was important to them because the daughter wasn't doing that well, and his wife came up in line, and the teacher started to leave, and she said, but you're leaving. And he said, it's 9 o'clock. I'm only required to be here till 9 o'clock. She said, but I really need to talk to you about our daughter. And he said, I can't. Union rules. I can't talk after 9 o'clock, and just, walked out on her. I mean, it's just incredible. So you get this mindset of not doing the job, but basically following the rules. It's this kind of central planning mentality.
Yeah, and I think one of the points you've brought up a couple times already is really important, and you bring it up a lot of times in the book. It's that this whole apparatus, this whole process is not that old, really. I mean, this all came out of the 1960s. A lot of the early labor leaders and a lot of early pro-union Democrats who were very much in favor of unions in the private sector in the 20s and 30s were strongly against unions in the public sector because they saw these exact problems with this encouragement to basically negotiate against the public.
Yeah, so FDR said the process of collective bargaining cannot be transplanted into the public service. And And union leaders felt the same way. It was a breach of the duty of loyalty. But there was another dynamic here that's really important that the public didn't understand, and frankly, the experts in the late 1960s didn't understand, which is that the difference between bargaining in the private sector and the public sector is not a difference in degree. It's a difference in kind. And I'll just give two reasons. In the private sector, what a union can negotiate for is limited, really strictly limited by market forces. If they argue for inefficient work rules, that business is going to either go out of business, so all the jobs will be lost, or it's going to move out of town, which is sort of what happened to auto companies in the 1970s. They just couldn't deal with all these rigid requirements. And in the public sector, the government can't move out of town, and it really can't go out of business. So what's happened for 50 years is that the taxpayers have been forced to pay a burden of work rules and unmanageability that conservatively waste half the money, and cause failure. So you've got this year, all these cities announced like what was happening with schools. So in Baltimore, there were 23 schools in Baltimore where not one student is proficient in math. Not one student. So if you were elected mayor, you're running, the thing you would do is you would do anything possible to shake up that school. You would change the leadership, you would change the teachers, you would change the way it works. They have none of those powers, because of the union. So it not only wastes conservatively half the money, but also makes it so that really important social institutions fail. Also, I have an appointment at a branch of the economics department at Columbia. We had a forum recently, and Neil Ferguson, the historian, was on the forum, and he talked about this problem as a really serious national security problem. That how can we possibly compete in the future with China and others if we can't do the most basic things because of all these, rigidities? We can't run schools properly. We can't solve the problem of the underclass. We can't build infrastructure efficiently, modern infrastructure, et cetera. So it's a serious problem. But the second point is not just the difference in what you can bargain for, but how the bargaining works. So in the private sector, if a corporate manager took money or benefits from the labor union, both the corporate manager and the union leaders would be put in jail. That would be fraud. In the public sector, and I go through lots of examples of this, the unions will spend tens of millions of dollars to get a governor elected. In the case of recent New Jersey elections, union employees ran the campaign headquarters for the governor. The unions provided busloads of union members who were then paid at per diem to man phone banks to get to go door to door to get the governor elected. And so then the governor gets elected and he sits down at the bargaining table with the unions as required by law to agree on the terms and conditions of employment. Is that a negotiation? No, it's a payoff. It's completely, it's unbelievably, obviously corrupt. And the unions crow about it. They say, we elect our own bosses. I mean, it's just unbelievable how arrogant they are about and shameless they are about this sort of derogation of morals and democratic governance. So the difference between public and private bargaining was not appreciated at the time they did this. It was all kind of, the people running the public employee associations have been angling for power ever since public employment became permanent after the spoils system was replaced by the civil service system. And they had been, rejected by Teddy Roosevelt, by, Wilson, by FDR, by LaGuardia, everybody. Then the 60s came along It was the rights revolution, and everybody was looking at things from the standpoint of how do we protect the poor individual, and it was just like falling off a log to finally give them collective bargaining power. And the experts who supported it, and I go through their discussions. No one, I think, has ever done this before. I went through all these sort of law school forums that were held on whether to allow public collective bargaining. Without any question, the people who supported it back in the late 60s would say that the way it evolved is unconstitutional. They
Yeah,
just had no idea.
yeah, let's get into the constitutional argument, because I think this is the real, this is the point of your book, but it's also one of the really sort of unique perspectives that I hadn't considered before reading it. And because for a long time, conservatives have made one constitutional argument against public sector unions, which is the First Amendment argument about being compelled to support public sector unions, and
Right.
the idea that being that public sector unions in all of their actions are engaged in political activism and political speech, and therefore coercing support for them is a violation of the First Amendment. And so the Janus versus AFSCME Supreme Court decision finally recognized that, and now that's
Right.
the law of the land. But you make a different constitutional argument with different parts of the Constitution. So if you can walk us through that.
Sure. So I think, what no one had done before, they'd made the First Amendment argument, but they hadn't looked at public employee unions through the lens of constitutional governance. Everyone sort of complained that they were inefficient and you had to deal with them. But I think people assume that because collective bargaining powers had been given to the unions by democratically elected legislators, and all these benefits had been given by democratically elected legislators and all these controls and such, that therefore that's just the way democracy works, right? That's, everyone kind of assumed that. But there's a lot of learning. I started looking at this initially in the context of the federal government, where there are many cases that hold that Congress lacks the authority to, for example, take away the president's power over executive branch personnel. This, a lot of learning. So once you realize that a democracy is not just about whether it was kind of authorized lawfully or not, but that the different branches have to retain their particular constitutional authority, then all of a sudden it's a different lens through which you look at this. So what's happened with the public sector unions is that Congress and the legislatures put a requirement of collective bargaining onto the executive that effectively took away their authority to manage effectively, which is, again, the facts are irrefutable. There's no accountability, et cetera. And they imposed all these other controls that are not budgetary controls or limits on public goals or whatever. They're actually controls on how the executive branch works. How you manage, the inability to walk into a classroom and observe how a teacher is doing, or look at test scores to evaluate a teacher, and that sort of thing. And no one had looked at it this way. And there's a basic constitutional doctrine called the non-delegation doctrine that comes out of John Locke's second treatise, which is that, and this is not the non-delegation that conservatives usually complain about, which is Congress giving lawmaking powers to administrative agencies. That's a variation of this. But the bigger non-delegation doctrine that comes out of John Locke, is that someone elected to public responsibility can't sell or give away their power to a private party. That you have the public trusted to you in a Republican form of government. That means you have a fixed number of years in which, so it's not a straight democracy. You have your 4 years or whatever to act on your best judgment in the public interest, whatever the public thinks. That's the sacred, so you can't give it away. It can't be given away. You have to retain it. And that's reflected in the Constitution in several places, the main one being something called the Guarantee Clause in Article 4, which provides that the United States shall guarantee to every state a Republican form of government. And what that means is whatever form of democracy a state decided to put in, and there's slightly different variations on it, whoever is elected has to retain their authority. They can't get, and James Madison talked about it. You can't give it to an aristocratic class, which they were worried about back in the late, 18th century, or to quote, any favored class. The officials elected had to retain their power. Well, what's happened quite clearly is that legislatures have taken away the power, and given it to the unions. The unions have an effective veto on how government works. I mean, they're sort of like a co-government. So you can't manage anything. You can't, democracy is nothing but a process of accountability. So you elect a mayor or governor who has no power to hold the people below him accountable. So how's it supposed to work? All the links in the chain are broken. Madison talked about that too. In the context of the president, he said, the lowest grade, the middle grade, and the highest must be accountable to the president. There's Supreme Court cases that talk about the exclusive and illimitable power of removal by the president of, executive branch officers. Well, there is no power of removal now. It's again, it's like 99% fully successful. So, if you look at it through this lens, I think it's clearly unconstitutional. And then, there are some steps forward that we can discuss about, little steps that the Supreme Court has to take in order to do what I'm saying, but they're not giant leaps.
Mm-hmm. Yeah, one of the best examples we have of a politician taking on public sector unions was Scott Walker doing this in Wisconsin. Right. And I'm from Wisconsin, and this was like one of my first political memories was this big fight at the Capitol building with all of these protesters, right. And unions sent all these people in, and I had teachers that were out sick to go protest and all that kind of stuff. And Walker was able to pull back the ability of unions to bargain on things other than wages, right? So he basically said you can collectively bargain on wages, but not all these other work rules and all this other stuff. He also said you actually have to contribute a little bit to your pension and a little bit to your health care. Again, up from zero, but still much better than the private sector, than most private sector workers, I should say. And he endured some ridiculous opposition from the unions and from Democrats in Wisconsin, but he was able to win 3 elections in 4 years, and he was also able to and now that we've had Democrats back in power in Wisconsin with a Democratic governor now in his second term, he hasn't tried to roll back any of these changes because taxpayers have seen that actually it's good to have a fully funded pension system, and actually it's education hasn't collapsed. The quality of education hasn't collapsed, right? So to what extent do you see the ability of other politicians to advance in the elected parts of government outside of the courts on this issue?
Yeah, it's a really illustrative story. First of all, there's no way that Scott Walker would have gotten elected if the unions had known he was going to go after collective bargaining this way. No way. They would have put $30 million into the campaign. So the next year, John Kasich got similar reforms enacted in Ohio, and the unions poured in tens of millions of dollars for a referendum to undo those reforms and got them all undone within a year. So we're talking about national money coming in at a preemptive level. So if they'd known that Scott Walker was going to do this, he never would have been elected in the first place, number one. Number two, when he did it, as you said, it was just in the brutal opposition. 100,000 people came to Madison. They occupied the Capitol. People have forgotten this. the Democratic legislators left the state so there wouldn't be a quorum to vote on the reform. He finally got them enacted. Then the national unions came in with tens of millions of dollars to do a recall election the next year. And then that was bitterly fought for a year, and then Walker, I actually helped him raise money during all this. And then Walker had to raise tens of millions of dollars himself just to stay governor. So he won that. And then the unions got a Democratic prosecutor to indict Walker.
Yeah.
For alleged, campaign violations in the recall election, and actually progressed with that until it was finally tossed out by the Supreme Court. It was 4 years of stuff, and Walker's career kind of never recovered from that. He got his reforms through, but it was like you were so mortally wounded by the battles and all that kind of stuff, you couldn't go anywhere. And then Kasich tried the same thing and then got completely reversed. So the political route is really not realistic. It's more like a civil war, and there are very few Republican leaders and no Democratic leaders who will take it on. But as you point, but I know a lot of people who are Democrats who are elected representatives. They would love to get rid of the union. I mean, everybody wants to make things work, and you're in a situation. Joe Klein was saying that, he's talking to Pat Moynihan. The one thing Pat Moynihan would never talk about are the unions. He's like the truth teller of all time. Because he got a lot of campaign support from the unions. He just couldn't. It's like a pact with the devil.
Yeah, no, that is one of the things about the book. I mean, obviously, taking on public sector unions has been seen as a conservative cause, but you don't really come at it from a conservative perspective necessarily. You come at it from a good government perspective. And I feel like that's something that progressives should care about too, especially if you're a progressive who wants the government to do more stuff. It seems like you should want it to be able to do it well and be able to do it within the legitimacy of democratic accountability.
I had a funny conversation with the head of a left-wing think tank who said, "Well, listen, I've read the book. I can't think of one thing in it that I disagree with. It would be so good for the country if we could get rid of this. But of course, I can't say a thing without self-immolating. So, so it has to happen without Democratic support. So one of the things I'm trying to talk some non-MAGA Republican candidates into is to, instead of being the party of no government, the Republicans should be the party of good government, which is we should cut back government to not do things it doesn't need to do, but whatever it does, it should do effectively. It shouldn't waste twice the money. It ought to be able to fix a bad school and fire a bad teacher and fire a bad cop, and all that kind of stuff. So why can't we quite? I mean, it's like a piece of ripe fruit just waiting for Republican candidates. And guess how many people in this country that will appeal to? Every parent, a lot of liberals, every business person who understands the importance, and everyone who works in a responsible job, the importance of accountability. It's just an unbelievably attractive issue, I think, for the Republican, for a Republican candidate, instead of kind of brutalizing government in the abstract, say, well, let's think about this. Let's do a spring cleaning, get rid of the stuff we don't need anymore so we can balance the budget, and let's make it work.
Yeah, no, I absolutely think that's right. And I agree with you. That's something that conservatives should prioritize, is talking more about how, a lot of these problems that we see in government are because of Democrats and unions basically creating these systems that can't be changed and can't be modernized and improved. And that is a huge opportunity for conservatives to come in and make that argument, especially when it comes to conservative priorities, which are things like the police, but also, increasingly education, because, we've been talking about that more recently. And just understanding the ability that politicians, when they get elected on a platform about education, they need the ability to actually go in and make the reforms that they
Right,
ran on.
right. So, I mean, it's really, the parties have kind of been stuck in a rut about talking about policy. Let's disagree on climate change or immigration policy or trade policy. And those things are all important. But no one really, since maybe Al Gore or something, has talked about the operating machinery of government. It's just how things work day to day. And I'm convinced that a lot of the alienation that people feel is because of a combination of government never delivering the way it should, the kind of frustration of dealing with Big Brother, and the fact that centralized government disempowers people. And so if you had accountable government, you could give much more authority at the local level so that people could actually feel they had a say in how the schools work and such. I mean, that's why Glenn Youngkin got elected. Parents didn't want the, central commands on what to teach. They wanted to be involved, and they should be. So I think it's a very attractive, looking at government operations and citizens' input into government operations and accountability within government operations and all of that is a very attractive potential line of, kind of reform for Republicans.
Yeah, and it's an area where the Democrats are the ones who are opposed to change, and the Republicans are the ones in favor of change, which I always hate the kind of conservative just means you oppose change. It's like, well, no, not on this, certainly, and not on a lot of other issues too. One part of your constitutional arguments about the guarantee clause, which says that, states are guaranteed a Republican form of government. It is a part of the Constitution that the courts have generally said is not justiciable, so they don't make rulings based on it most of the time. I'm in favor of a more muscular interpretation of it, quite frankly. I would like to see it applied for many of the same reasons that you list for public sector unions. I would like to see it applied to things like legislating by ballot initiatives, where you have these ballots in California with this massive list of things where legislators are basically delegating their lawmaking authority to special interests because all of that is spent, they spend tons of money on this, and they're basically giving up the power that the voters gave them to make the laws, and are giving it up to these kind of special interest campaigns with these really confusing ballot questions that nobody understands. But the courts don't agree with me on that. They say, Republican form of government, that's not justiciable. We're not going to get involved in that. So what do you think about the public sector union case that the courts will look at that clause of the Constitution differently and use it to invalidate the way that things are right now?
Yeah, really, really important question. I mean, there have been 3 or 4 Supreme Court cases on the guarantee clause, all of them holding that it's non-justiciable, including one from the turn of the last century, the Pacific Telephone case that someone made an argument similar to the one that you're talking about whether having things decided by voter referendum is a violation of the guarantee clause. And the Supreme Court in those cases basically said, when you have an issue in the first case, which is which of 2 Rhode Island constitutions is more Republican than the other, that should be decided by the legislature or by voters. It shouldn't by a political branch, not by the courts, and it's non-justiciable. What makes the argument with public unions different is that we're not talking about a partisan value here. We're not talking about whether it should be gerrymandering or which constitution is more Republican, or whether even a referendum initiative is not shouldn't be enacted. What we're talking about is the constitutional authority of an executive to do his job. It's not. It doesn't matter whether it's a Republican or a Democrat. The executive can't do the job if they've been disempowered and the power has been given over to the public unions. So it's not a partisan issue. nor is an issue that can be really fixed politically, because one branch of government, the legislative branch, has taken away the constitutional authority of the other branch. So why do you expect the legislative branch then to somehow take that back? I mean, it's not. So, so I think it does require the court to step forward. There is some basis for this argument. Justice Brennan in Baker v. Carr, which was the one man, one vote case from 1962, had a discussion of this. And he said that while the guarantee clause should be non-justiciable in cases involving political questions, it should be justiciable in cases involving the structure of government and, whether it works. So I'm, who knows what the Supreme Court will do with it, but but what the Supreme Court says is the Constitution is what it means, and I'm pretty comfortable that many of the justices, maybe even the liberal justices, will be sympathetic to this, because we're talking about the circumstances for government to work. I mean, it just can't work, And so this is a liberal value just as much or more than it is a conservative value. So,
yeah. And you want to tell people really quickly what sort of litigation and legal cases are already in progress on this?
Yeah, so we're talking to, I have 4 or 5 public interest law firms we're working with, including the lawyer who argued the Janus case in the Supreme Court, who wants to work on it. So we're there's the Liberty Justice Center in Chicago, I think, is working on a case that would challenge the recent referendum that amended the Illinois Constitution that provides, unbelievably, that union collective bargaining agreements supersede both past and future statutes. Literally, they basically supersede democracy.
Yeah.
I mean, it's just, how can that possibly be constitutional? I mean, the concept of overreach means nothing to the public employee union. Yeah.
Well, all the best of luck to you. I really hope it works. The book is Not Accountable. The author is Philip Howard. I highly recommend you check it out. It's a very readable book. It is not very long at all, but it's chock full of lots of really specific examples of union abuses, but also examples, like he said, of going through the history of how we got to this point and actually understanding the process that led to this. And when you do that, you really understand how screwed up it is and how much it needs to be fixed. So thank you so much for being with us, Philip.
Nice to be with you, Dominic.